Hello and welcome to the CIArb PolicyCast, the show where we discuss current issues on the cutting edge of ADR. My guest today is the stellar George Lim. Mr. Lim is a consultant at the Wee Tay and Lim LLP, a former president of the Law Society of Singapore, as well as a founding member of the Society's Criminal Legal Aid Scheme, which provides free legal representation to accused persons who are unable to afford a lawyer. He mediates regularly at the Singapore Mediation Center and have conducted many multi-party claims as well as claims involving international parties with an extremely high success rate. In 2014, George was identified by the international who's who of commercial mediation as being among the world's leading commercial mediators. George, thank you for being here.
Oh, thank you for having me, Ludvig.
Of course.
It's good to be here.
Sorry?
It's good to be here.
It's good to have you on. If I could just start, could you tell our viewers a little bit about yourself, your background, and some of your key experiences working in the field of mediation?
Okay. Well, I was called to the bar in 1981. I've been practicing for 38 years now. I'm a senior counsel, and many years ago, I was president of the Law Society, as you alluded to. That was in a different life. So I started practice as a litigator. And then I went to arbitration. About 20 years ago, I started arbitrating. I'm on a panel of CIAC. And mediation came into my life like 23 years ago. Did a course in CIDA in the UK. And then I went on to Harvard to train with Frank Sander. So that caught my eye because it was, for me, like law has always been something you want to be useful to help parties. And I saw mediation as a different way of helping people resolve disputes. So I've done like 500 mediations now, quite a good success rate, 75 to 80%. And 5 years ago, I decided to do this full time. And so now I mediate like once or twice a week, good cases, interesting cases. I had one on Thursday, and it keeps me going. My experience with mediation, I think the last thing was with the Singapore Convention on Mediation, and we could talk about that later, but I was part of the Singapore's delegation to the working group. Yeah, that was a very rich experience.
Well, thank you for bringing it up and talking about actually making a difference within mediation and ADR. Some universal development goals like justice and fair competitions and these notions has come increasingly to be represented by the mediation industry, for example, through the Singapore Convention on Mediation. And I was wondering, looking ahead, do you see that parties increasingly is shying away from arbitration and towards mediation?
Okay, I would like to see it in a positive way. I don't think it's a zero-sum game. I think clients and parties just want their problems to be solved in as quick a manner and as cost-effective a manner. And that's the reality. You will also know that the trend today is actually towards hybrid ADR processes. So it's about trying to design something or trying to do something for the client which helps them to solve the problem. And if you have to use litigation, arbitration, or mediation, for me, let's find the best way. So people are using a combination of hybrid processes, different forms of dispute resolution. A good example would be, SIAC, which is known by many people. They're an arbitration institution. They're a sister company of SIMC, for which I chair, Singapore International Mediation Center. And we have a protocol called the SIAC-SIMC ARB-MEDAP protocol. That is something which we've offered to people. So if you are concerned about enforceability, come to us. We'll register your case as an arbitration. Tribunal is formed, initial papers are filed, and then there is a stay. The tribunal will stay the arbitration for 8 weeks. So we have this window of 8 weeks, and the case comes to SIMC, different organization. We appoint a mediator, a different person, and then we try to mediate the case. And if it's successful, that settlement agreement goes back to SIAC and then is recorded as a consent award, which is enforceable around the world, in 160 countries. So we found that to be very, very attractive to people. In fact, 20% of our cases are AMA cases. And of course, if the matter doesn't get resolved, then it goes back to SIAC for arbitration. So people have found this, they want the option of arbitrating, but at the same time having this mediation element to help them, a structure which helps them, or a framework which helps them to at least try to resolve the matter. And for me, that is the way to go. Lawyers of the future, young people ask me, what's the future? And I say, look, for the lawyer of the future, pick up the different skills. Design, you must have the ability to design processes which actually help the client. We see ourselves as arbitrators, litigators, mediators. The clients don't look at us that way. They just want someone to help them solve the problem quickly and effectively. So for me, it's not a zero-sum game. I think there's enough work out there, but it's how you use your skills and how you use the different dispute resolution processes in the best form. Yeah, so I'm keeping it. I'm positive about.
Well, I'm happy to hear that, and I was, to follow up, applying yourself to this way of thinking, and especially in regards to the hybrid approach to dispute resolution. Is there a particular industry or particular set of companies that you can see that are kind of utilizing this method more than anyone else?
So I told you at SIMC, like 20% of our cases do this, and there are all sorts of cases. It doesn't matter really, so long as the parties are willing and the circumstances fit. I'll give you an example. I mediated one case some time ago. Involved the sale of oil palm, Indonesian party and an Indian party, and they had gone for arbitration. The claim was I think the maximum claim would be 5 million or so. Not a lot, but enough. They went to arbitration. One party won. The other party then appealed on the ground of breach of natural justice. Okay, that it wasn't given the opportunity to present its case properly. It went to the High Court. The High Court agreed, sent the case back to the tribunal, and then the tribunal made another decision. Then it went back to the High Court on appeal. It was ding-donging for years. The parties were so tired, and the lawyers did the most sensible thing. They said, let's go and try and mediate this. And they came for mediation. And the dispute happened years ago. The sons of the fathers who had the dispute came to the mediation. and they told me, look, we don't have this baggage. And it's been so many years. And I said, do you know it's breach of natural justice? And they said, it's something which we lawyers are really keen to find it out. But for them, no, So that's the reality. In one day, we settled the case. They stood up, they talked, they shook hands. And everybody was happy, including the lawyers, because I think they found that this was the sensible way forward. So for me, this is how it goes. If parties are willing, try different means. Try, and mediation is suitable so long as the parties are willing. You've got to be able to give and take, But in the end, it made commercial sense for the parties to sit down and talk and work it out. They would still be up and down in court otherwise.
Well, it's interesting that you mentioned the kind of, for example, you brought up a transnational dispute because I was thinking about with the increasing number of disputes actually involving both state actors and commercial ones and being transnational in their nature, what are some of the sort of cultural and constructive issues facing mediators of today, and how is a good way to kind of overcome these?
Okay, good, very good question, because increasingly now with global trade, you find a lot of cross-border disputes. And to be able to mediate cross-border disputes, it demands a different kind of skill. You need to have an understanding, I think, of the culture of the different parties, and it could be very different. A Chinese from Singapore will be very different from a Chinese from Hong Kong or Chinese from mainland China, and of course, I mean, we can't just take it as if it's all the same. You've got to understand, and you've got to spend time preparing. I give an example because I think that's probably the best way to explain mediation which the SIMC did 2 years ago in Seoul, in South Korea. A dispute between an American party and a Korean party. They were in a joint venture in another Asian country. It went sour, and the American party blamed the Korean party. And they didn't want an American mediator. They didn't want a Korean mediator. They found somebody from Singapore. So I flew up to Seoul. I did the mediation with them. And it was very tense because the cultures are quite different. Okay, this Korean part was represented by a lady. Actually, it was quite traditional. The Americans were represented by counsel who was quite used to being very forthright and very strong. And the styles were very different. So I had to think of a way to try and break the tension. So you know what I did? I went to the supermarket. I bought a teapot, Korean teapot. I brought some Singapore tea, Singapore TWGD. And just as we started the mediation and we introduced ourselves, I poured tea for them. So we started off the mediation with a cup of tea. And I asked them later, because we settled at midnight that day, but I asked them later, and they said that helped really, because they didn't expect the mediator to come into the room. They expected it to be very formal, like in a courtroom, but they didn't expect that. But that, I think, broke the ice and got parties to start talking. So to me, you find a way to break the cultural differences. In the end, we're all human beings. How do we get ourselves to talk in a reasonable manner? So there are differences. So like, for example, Asian parties, in mediations, we have private caucuses, we have private sessions, we have confidential. Asian parties need, from experience, we found that they need, they'll probably be more open with you in a private session than in a joint session. But an Australian party or an American party will have no problems, telling you what they feel, what they need, openly. But you find that cultural difference, and to be able to try and prepare so that you get people thinking along the same lines. But it's really interesting,
Yeah,
it's just not about law, but about people. Yeah.
Yeah, that was my follow-up question, because most legal scholars, or if you undergo legal training, you tend to think in very traditionalist ways about how to approach procedure and conflict resolution in any case, civil or what it now might be. But do you think that an approach like the one you mentioned now is more beneficial, really, than going into something very high-strung or being very methodical about things?
Well, I think you need that kind of training too, because I started off with that training, and it's good discipline. But with in life, with experience, you've got to change. You've got to be able to be flexible. And for me, thinking back now, I think I would have benefited if they had taught me dispute resolution as opposed to civil procedure and litigation. And because we're in Singapore, we're a common law jurisdiction. And to teach us law in that just that one way, whereas the civil law jurisdictions, you have such a rich experience, and I never learned that except in practice, and now I'm trying to pick up things, but to try and understand, the same word may mean different things. So I'm all for universities teaching dispute resolution as a whole. Don't teach us just to be arbitrators or mediators or litigators. Teach us, to have skill sets in all the different fields, and also the what you talk about. I mean, about life, about people. Mediation, you need people skills, because it's humanizing that legal problem also. Because in the end, behind every dispute, it's a person, it's a party. So again, for me, I come back to that theme of mine about hybrid processes. I think that is the way forward. For us to be taught to be dispute resolution specialists, and not think of ourselves in just one box. We are litigators or we are arbitrators. The clients don't see us that way anyway. They just want someone to help them. Yeah.
I guess that will to kind of get your problems resolved is universal. Yes, if I may go on a tidbit here and ask you, by being based in Singapore, What would you like for ADR providers in the country, as well as maybe in the greater APAC region for that matter, to take going forward in promoting mediation and excellence in providing mediatory services? Is there anything that you see that is, a particular thing to strive for, or is this something that should be shied away from?
So to me, I said at the start, it's not a zero-sum game. For me, it's not about competition, but about collaboration. And I wish that, all the different dispute resolution bodies, we can do that, and that we can see beyond that and focus on the needs of the user. Go back to that. Because in the end, I mean, we all, when we became lawyers, we all took an oath to act in the best interests of our clients. And so for me, let's try and focus on that and see ourselves as people with different skills who are able to help the parties, so that the world maybe could be a more peaceful place.
We can all hope for that, I hope, especially now in this day and age. If before we go, I was wondering, do you have any specific industry insight or curious tidbit that you could share with us that you think people outside that aren't in the know that could be interesting for us?
Well, for me, the Singapore Convention on Mediation is now the topic. Wherever you go for conferences, people are talking about it. And I was very fortunate because I was a part of the working group, because there was a delegation from Singapore and I was part of that. And so for like close to 3 to 4 years, we were having meetings in Windsor Trial, in New York and in Vienna. And it was I told you, it was a tremendous experience, because the working group comprised 50 states and people from different jurisdictions, civil and common law jurisdictions. And to be able to cobble together, a convention it was really very satisfying, and it was a great learning experience. But to me, what's significant is that, on the first day when the convention was signed, it was 7th of August last year in Singapore, 46 countries signed that convention, which I'm told is the record for UN documents nowadays. And of the 46 countries, we had the US, China, India, 3 very big trading partners in the world, and they comprise, I think, more than half of the world's population. So if you had asked me when we were deliberating at Windsor Trial whether we get 46, I didn't know. If you get 10, you'll be lucky. But we had 46, which actually demonstrates that there is a lot of interest in the ground in mediation. Our court systems, arbitration systems, we cannot take the load. There are just too many disputes in the world. We have to find different ways of resolving disputes. And to me, that was a signal. And people were interested in enforceability, and that was what the convention offered. I think also that 5 countries have now ratified the convention, and it will come into effect on next month, on the 12th of September. And this bodes well for the dispute resolution world. So I know arbitrator friends who say, look, mediation, you see it as a threat. I say, don't. Okay, this is us as a dispute resolution body moving together. You've got the New York Convention for Arbitration. Now you'll have the Singapore Convention. It's sort of, the missing puzzle is there now. It fits, and this is all good for world trade, for global trade, and for countries to come together. So I see this as a good thing, and it's something which I think people want to look up for. So if you don't know about the convention, please, there's a lot of material out there. Their website is, pick it up, go for courses. But this, for me, this is the most significant thing which has happened for mediation in the past 10 years, 20 years.
Well, thank you so much, George, and thank you for leaving us with such a hopeful message. I think we can all use a bit of positivity right now. Again, thank you so much for coming on. We appreciate it so much.
No, thank you for having me.